Abhishek Singhvi.
Sir, I congratulate the honourable member not so much on the legislation he proposes, not so much on the wording, but on the spirit which animates and lies behind it. I think the spirit is important to be appreciated. What is the idea? The idea is to ensure that collectivity of decision making will give us a better decision. If 2 heads are better than 1, then 3 and 5 heads are normally supposed to be better than 2. It is interesting that in the apex court, the Supreme Court, there is a rule from independence till now that no judge of a single bench can hear matters. That is not so in the high courts and the lower courts, but in the Supreme Court, a single judge cannot constitute a bench for any matter except some very small inconsequential chamber matters in lunchtime, except that it has to be minimum 2 judges. Now the spirit is the same as the resolution proposed by my friend. The spirit is that if you expand the decision making base, you are likely to get a better decision. But let us apply it to the issue which the honourable member has raised. The issue is, in our system, there is a hierarchy of laws. At the top stands the Constitution of India. Below the Constitution of India stands a statute of parliament, legislation. Below that stands delegated legislation, namely notifications or rule-making powers. Below that stands executive orders and so on and so on. Now, the honourable member's spirit behind the resolution is illustrated by a simple thing. When the Supreme Court or the High Court decides to consider a constitutional amendment and its validity or not, it normally constitutes a bench of 5 or 7 judges. For example, in the famous basic structure of the Indian Constitution case, Keshwananda Bharati, we had the largest bench ever, 13 judges. 13 have never sat before. Prior to that, in Golaknath's case, which was overruled by Keshwananda Bharati, you had 11 judges. What is the idea behind this? The idea is that human beings, including judges, are necessarily fallible. They are necessarily prone to error, as all of us are. Because to err is human and to forgive and forget is divine. And therefore, you must have more and more people participating in important matters of moment, including matters involving high constitutional principle or legislative principle. So that is the spirit behind my friend's resolution. If you apply it to the hierarchy which I have just said, where the constitution is top but legislation comes next, and below that comes a whole range of delegated legislation, then it's very important that legislation be not struck down casually, legislation be not struck down frequently, legislation be not struck down without application of mind. You can have variants to my friend's resolution. For example, as a matter of practice, not as a matter of law, courts very rarely stay legislation. If there is a notification or a delegated legislation, the court may or may not stay more easily. But if there is legislation, interim stay is not normally granted as a practice of the court itself. Why is that? Because legislation is given higher status. It is something which goes through the collectivity of this house, of the next house, of the President of India. And that is rightly entitled to more weight. Therefore, I think this is a salutary rule. It is something which is desirable in the public interest. It takes account of realities, because adjudication, judgment giving, decision making is a peculiarly human task. It is something which has to have subjectivity varying from judge to judge. And that subjectivity cannot be eliminated. We are all human beings. But it can be minimized. You can minimize subjectivity by having larger collectivities. And that is the spirit behind the honourable member's resolution. Secondly, and a word of caution here, the word of caution in respect of an issue which the honourable member may not even have anticipated. Although this is desirable in the interest of the nation, there may be issues of constitutional validity of this resolution itself. Because given the powers exercised by our courts, given what one might call the current phase of judicial activism sweeping across the length and breadth of the country, not only in one court but across the board in different courts, it is entirely likely that a law which says that you shall decide only in benches of 5 or 3 may itself be struck down as being supposedly an unconstitutional interference in the working of the courts by the courts themselves. That is an example of judicial activism and unconstitutionality. Of course, whether this will happen or not will depend if and when a law is passed, if and when it is challenged. But certainly in principle the law is desirable, and if and when it is passed, and if and when any court decides to strike it down by saying that we are being forced to decide in collectivities which we don't want to do, then you may even have to consider a constitutional amendment of the same provision, with the same provision. Sir, behind this lies the larger debate of judicial activism versus judicial restraint. It is not necessarily a debate which is today before the House in its full comprehensive contours, but certainly it is the bedrock and the sentiment which lies behind some of the issues raised in today's resolution. Sir, judicial activism and judicial restraint, both again, as I said a few days earlier here, in my humble opinion represent extremes, and the golden virtue lies really in between these extremes, because as Aristotle said, extremes are always vices, the virtue lies in between. Take for example, sir, public interest litigation. Public interest litigation is an innovation of the judiciary in India of which we are rightly proud, justly proud. It was invented in the early 80s and the late 70s to deal with certain issues of physical human rights violations. But sir, PIL is an unruly horse. An unruly horse depends very much on the dexterity of its rider as to how well the horse will perform. The rider has to be dexterous, and therefore the concept of PIL may be good, but if the riders are spread over 5,000 different judges with 5,000 different approaches all over the country, naturally sometimes the horse may be allowed to become far too unruly. It is therefore necessary to realize the subjectivity in judicial decision making and adjudication. It is therefore important to realize that while on the one hand legal and judicial concepts may be good, they have to be exercised within the rubric of self-denial, of self-restraint. As somebody has said, the greater the power, the more important to use restraint in its exercise. Over-frequent use of a potent power dilutes it, makes it less efficacious, and that is what all organs have to realize, including the judiciary. It is the constitution which is supreme. The constitution draws the Lakshman Rekha between three organs, between the executive, the judiciary and the legislature, indeed between the other estates, organs of estate, namely the press and other organs. This Lakshman Rekha cannot be transgressed merely because what the constitution says and what it means is given to one of the three organs. What the constitution says and means, no doubt, is decided by one organ, but in the guise of deciding it, you cannot expand your own Lakshman Rekha and redraw it. And that is the crux of decision making. That is where the errors sometimes occur, and that is why where the errors can be reined in by creating a larger collectivity, and that is where the resolution moved by my friend has some relevance. Sir, where on the one hand judicial activism or judicial power can do good, it can easily become farcical sometimes. We are not here in this house to discuss individual cases, but for example, would a public interest litigation power be usefully used to deal with monkeys in Delhi, to direct that monkeys in Delhi be re-exported out of the city to other states? Is that a fair and proper and correct use of this power? An interesting thing can happen, that the receiving state can object that we do not want langurs exported from Delhi in our own state. Under what power can you direct that a langur be exported from here into our own state? They are a threat to humanity in my own state. Now this is an issue where you have to realize where the Lakshman Rekha will be drawn, and therefore sometimes the collectivity which is underlines, or the larger bench, or the 5 judges or the 7 judges or the 3 judges, the numbers are not relevant, can make a difference. Sir, ultimately one must realize that by its very nature, the judicial function is different from the executive function and the legislative function. The judicial function has several positives, it has several plus points, but it has some inbuilt negatives. And I'm not talking Judge A or Judge B, it has inbuilt negatives in its very nature. The inbuilt negatives are a judge-made law is individual law made in individual cases. The law expands by deciding individual cases. An individual case may have individual features, but in deciding it, you lay down general principles which apply well beyond the narrow individual facts of that case. This is the essence of judgment giving. This is the essence of judicial law creation. Now, therefore, because in the course of deciding the facts of a case, you are laying down law for other cases, it is all the more important to exercise a certain self-imposed limitation, a certain self-imposed restraint. It is all the more important to ensure that the subjective element and the objective element are clinically separated. The subjective element is necessary. It is necessary because it is the facts of a particular case which enable a judge to do justice in a case. But along with the subjective element, there has to be the objective element that if I lay down, apart from the facts of a case, a general principle, you have to anticipate that there are going to be some subsequent cases where that same principle may be well misused, may be well misapplied. And that is where the collective decision making is important, because when one judge may decide to expand the frontiers of the Lakshman Rekha, another judge may rightly decide to pull it. And that is why I think this must not be seen as a onslaught or an attack on the judicial functioning. It is only meant as a facilitating technique to remind all organs that it is not the individual discretion or the individual opinion which matters for the nation, it is the collective opinion of the court which matters. Now, I must tell you that there are several countries where the apex court, in our country, as I said, the apex court is unique in that it has to sit in benches of 2. And by convention, in matters of constitutional validity, they sit by convention in benches of 5. But there are some courts, sir, America for example, where the apex court by the Constitution of America can only sit together. No benches can sit. Of course, their court is half the size of our court. They have 11. But all 11 have to sit together, what they call en banc, and not separately. The same principle, the same reasoning. They can also sit separately. By sitting separately, they can dispose of more cases. But since the US Supreme Court deals mostly, almost entirely, with matters of public importance, of constitutional law, they have an invariable rule that the entire court sits together. Take, sir, for example, the House of Lords, which is the apex court of England. The House of Lords, in no case, whether constitutional or non-constitutional, and like in India, the House of Lords, like our Supreme Court, decides matters not merely constitutional, but matters beyond the Constitution also, ordinary matters, private law disputes. Unlike the US Supreme Court, which decides mostly constitutional matters. The House of Lords does not ever sit in a combination less than 5. Sir, I am not suggesting that for every matter, India it should be 5. There are reasons for that. There are logistic reasons for that. We don't have enough judges in the apex court. If the whole court or 5 people were to sit in every matter, our disposal rate would come even further crashing down and the huge areas would increase. So that is not the point. The point is that for important matters or for matters which involve a challenge or a stay or a voiding or an invalidation of legislation, there is no reason why the court should not itself sit in benches beyond a certain minimum strength. And I would, in fact, sir, with your kind permission, opine that when this august House, if and when this august House so opines, this is possible by a simple change in the rules of the Supreme Court. As you know, the Supreme Court has a Supreme Court rule book. You don't need legislation for it. You don't need an act of parliament for it. You don't need any constitutional amendment. The Supreme Court rules can be simply changed. It says today that all benches have to sit at a minimum strength of 2. And it also says that all benches have to sit at a minimum strength of 5 for constitutional matters. It has to add only one clause. The clause has to say that whenever an invalidation of a legislation is imminent or likely or asked for, then the minimum bench should be X. That X can be debated, whether it should be 5, perhaps it's a good figure to have 5. But the point is that this can, and I submit, it should be done, sir. Sir, may I therefore congratulate the member for something which is deeper than it looks, for something which is in the national interest, and for something which is a little noticed fact, but which deserved to be highlighted in this August House. Thank you, sir.